Welcome to all. Today, as a part of the course on insolvency and bankruptcy laws in India, today we are going to discuss the concept of persons ineligible to act as a resolution applicant. So in the previous classes, we have discussed the concept of expression of interest and public announcement when the resolution professional is appointed and COC is formed. Then subsequently resolution professional is going to give the public announcement. Then he is going to invite the expression of interest. Then subsequently the prospective resolution applicants, they are going to submit the resolution plans. So in the previous classes we have discussed about all these things. Today we are going to discuss the persons who are not eligible to act as a resolution applicant. So that means certain categories of people who cannot file a resolution application. Okay. So section 29A. Section 29A of IBC provides for the persons who are not eligible to be resolution applicant. Let us look at section 29A in detail. A person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person. So here, who is considered to be person? Already we have discussed the definition of person. Person includes natural person as well as artificial personality. So when you look at the section 29A, which provides that a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert. So possibility is that person may be acting individually, may be acting jointly together, two or more people together, they are acting together or in concert. Okay. So we are including person acting jointly in concert. Okay. Is an undischarged insolvent. This is the first category of the person who is not eligible. Okay. So any person who is undischarged insolvent, he cannot file an application for resolution plan. Okay. So that means he cannot file a resolution application. Then is a willful defaulter in accordance with the guidelines issued by the Reserve Bank of India. So under Banking Regulation Act 1949, Reserve Bank of India is going to declare willful defaulters. Okay, so if any person fails to make the payments, then there are certain criteria are there to call them as willful defaulters. If RBA declares any person as a willful defaulter, such person cannot be a resolution applicant. Then at the time of submission of resolution plan, has an account. So we are having three categories under this. Okay, so at the time of submission of resolution plan, who has an account or an account of corporate debtor under the management or control of such person. So first category, any person who has an account or else any corporate debtor, okay, so under the management or control of such person or of whom such person is a promoter classified as a NPA. So subsequently we are going to discuss about these three categories in detail. Okay. So if any account is classified as NPA, okay, and such person and such corporate debtor under the management or control of such person or whom such person is a promoter. Okay. These three categories are not eligible to file a resolution plan. Then, provided that the person shall be eligible to submit a resolution plan if such person makes a payment of all overdue amounts with interest thereon and charges relating to non-performing asset accounts before submission of resolution plan. So here in the previous class we have discussed that if any NPA is there, then such person is not eligible to, we are having various three categories of the persons. Let us discuss subsequently. So if NPA is there, such person is not eligible to submit the resolution plan. But if such person clears or if he makes a payment of overdue amount along with the interest and charges relating to non-performing assets, then in such cases, such person shall be eligible to submit the resolution plan. Second proviso, provided further that nothing in this clause shall apply to a resolution applicant where such applicant is a financial entity and is not related party to the corporate debtor. So this clause will not be applicable. This section will not be applicable if such person is a financial entity. Okay, so because financial entity, there is a regular activity to lend the money. Okay, so that's why to the financial entity, and these financial entities are regulated by regulatory authority. So as already we have discussed in the previous classes, these financial entities are regulated by the Reserve Bank of India. So that's why for them separate rules and regulations will be applicable. Okay, so that's why section 29A provides that this section is not applicable to financial entity. Let us look at the explanation. What is the meaning of related party? So because in the previous clauses there is a word related party. Okay, so what is the meaning of related party? Let us discuss about the concept of related party. So for the purpose of this provision, the expression related party shall not include financial entity regulated by financial sector regulator. So if the financial entity is a related party, okay, then in such cases such financial entity shall not be considered to be related party. Okay, so if it is a financial creditor of the corporate debtor and is a related party of the corporate debtor solely on account of conversion or substitution of debt into equity shares. So this concept already we have discussed in the previous sessions also. Okay, suppose if any financial creditor who happens to be financial entity who gave some loan to the company, any corporate debtor, then this debt is converted into equity. When this debt is converted into equity, the financial entity is going to have a stake, some equity capital in the corporate debtor. Merely because they are having equity capital, they cannot be considered to be related party. So this concept already we have discussed in the previous lessons. Okay, so related party shall not include a financial entity regulated by the financial sector regulator. Okay, because merely because they are having equity capital, equity in the corporate debtor, they cannot be considered to be related party. Explanation 2. For the purpose of this clause, where a resolution applicant has an account or an account of corporate debtor under the management or control, this is in detail explained in the subsequent concepts, under the management or control of such person or of such person is a promoter classified as NPA, and such account was acquired pursuant to a prior resolution plan approved under this code, then the provision of this clause shall not apply to such resolution applicant for a period of 3 years from the date of approval of such resolution plan by the adjudicating authority under this code. So what they are saying here, if you look at the explanation 2 clearly, where a resolution applicant has an account. So already one of the person has acquired another company, imagine. Okay, then that person wants to make an application presently. Okay, so where the resolution applicant has an account or an account of corporate debtor under the management or control of such person or of whom such person is a promoter. So now suppose take the example, one company wants to participate in the CRP process and they wanted to file resolution application. Okay, but that company was already taken over by another person. Okay, through the resolution process. So when it was taken over by another person through the resolution process, there is always a possibility, okay, NPA can be there. So that's why they are giving an exception. Okay, such account was acquired pursuant to prior resolution plan approved under this code. So that means already that NPA was acquired through CRP process. Okay, now the same entity wants to be resolution applicant in the present CRP. Okay, then in such cases they are exempted. Okay, this section is not applicable. Then has been convicted for any offence punishable with imprisonment. Okay, if any resolution applicant is convicted for an offence which is punishable with imprisonment for 2 years or more. So what is the condition? For 2 years or more under any specified legislation, under any act specified under 12th schedule, or for 7 years or more under any law for the time being in enforcement. Okay, provided that this clause shall not apply to a person after the expiry of the period of 2 years from the date of his release from the imprisonment. So who is not eligible to be a resolution applicant? If any person is convicted for any offence. Okay, so under schedule 12 you are having a list is there. So if any person is convicted under the acts or under the legislations which are specified in schedule 12, if there is an imprisonment is there for 2 years or more, Or else generally also if any person is imprisoned for more than 7 years or more, then in such cases, such person, whoever is convicted, such person is not eligible to act as a resolution applicant. Okay, but if the imprisonment is completed and he was released from the jail, okay, 2 years is elapsed, then in such cases, again he can be resolution applicant. Provided further that this clause shall not apply in relation to connected person referred to in clause 3 of explanation 1. So generally, in the normal circumstances for other disqualifications, even related party are also disqualified. But here, in case of imprisonment, related parties will not be disqualified. Next category is disqualified to act as a director under the Companies Act. So under the Companies Act, we are having certain categories where a person can be disqualified to act as a director. Okay, so Companies Act 2013 is not prescribing the qualifications to become a director. Okay, other than the DIN number. Okay, there is no qualification to any person to become the director of a company. But there are disqualifications are there. Okay, so if any person is disqualified to act as a director under the Companies Act, then he is not eligible to be resolution applicant under this act. Then next category is prohibited by SEBI from trading in securities or accessing the securities market. So if any person is prohibited from accessing the market, maybe there is a violation of insider trading regulations are there. Okay, maybe SAS regulations, like that various regulations were there which were passed by SEBI. So if there is any violation is there under certain provisions of the various regulations, SEBI may prohibit any person from accessing the market. So if any person is prohibited from accessing the market, stock markets, then in such cases, such person cannot be resolution applicant. Next category has been a promoter or in the management or control of corporate debtor in which preferential transactions, undervalued transaction, extortionate credit transaction or fraudulent transaction. So generally it is called as PUEF. Okay, so preferential transaction, undervalued transaction, extortionate credit transaction, fraudulent transactions. Okay, so if these transactions were there, so these transactions you are going to discuss in the subsequent lessons as a part of liquidation. Okay, so when we are discussing the liquidation, we are going to discuss in detail. Okay, so where we are going to discuss the concept of avoidance of transactions. Okay, whenever you are having PUEF, that is preferential transaction, undervalued transaction, extortionate credit transactions, fraudulent transactions, then such transactions can be avoided, okay, while you are going for liquidation. Okay, so anyway we are going to discuss subsequently in the subsequent lessons. Okay, so if any person is a promoter or in the management or control of any corporate debtor where this PUEF transactions are there, then in such cases such person cannot be resolution applicant. Then provided that this clause shall not apply if a preferential transaction, undervalued transaction, extortionate credit transaction, fraudulent transaction has been taken place prior to the acquisition of corporate debtor. So even that company was acquired by another person, maybe through CRP process. Okay, and the preferential transaction, this PUEF transactions were taken place before acquisition. Okay, in such cases this disqualification is not applicable. Then next category, next disqualification, has executed a guarantee in favor of a creditor in respect of a corporate debtor against which an application for insolvency resolution made by such creditor has been admitted under this code, and such guarantee has been invoked by the creditor and remains unpaid in full or part. So this is in case of this is the case of corporate debtor, guarantor to the personal guarantor to the corporate debtor. So any person who has executed a guarantee in favor of a creditor in respect of the corporate debtor. So that means one corporate debtor is taking loan from one creditor. For this, one person is giving guarantee, okay, in favor of the creditor. Then in such cases, such person, whoever gave the guarantee, is not eligible to file a resolution application. Then is subject to any disability corresponding to clauses A to H under any law in a jurisdiction outside India. So in India, we have discussed the conditions in India. Suppose if any person outside India, he wants to be a resolution applicant, then if he is subject to any disability, okay, they may not have, in such country you may not have the same provisions, but more or less similar corresponding provisions are there. Then in such cases, according to the law to which he is subject, Okay, if he is ineligible, then in such cases in India also he is ineligible to file a resolution plan. Okay, then has a connected person not eligible, clauses A to 1. Okay, if any person is a connected person, then also he is not eligible to be resolution applicant. Explanation 1. For the purpose of this class, the expression connected person, who is considered to be connected person? Connected person means any person who is a promoter or in the management or control of the resolution applicant. So whenever if somebody wants to resolution applicant, so to that person, if any person who is a promoter or management or control of the resolution applicant, suppose one company wants to be resolution applicant. So if any person is a promoter or in the management or having control over the such company, then this person is considered to be connected person. And any person who shall be the promoter or in management or control of business of the corporator during the implementation of resolution plan. So when resolution plan CRP process going on against one company, okay, so in such company someone is a promoter or someone is having management or someone is there in the management or someone is having control over the business of the corporator. Then in such cases, such person, whoever is a promoter or in the management or control of the business, he cannot be resolution applicant. Okay, so he is considered to be connected person. Then holding company, subsidiary company, associate company or related party of a person referred in clauses 1 and 2. Okay, so in case of holding company, subsidiary company, associate company, even they are also considered to be related persons or connected persons according to this section. Let us discuss. Provided that nothing in class C, class 3 of explanation 1 shall apply to a resolution applicant where such applicant is a financial entity and is not related party of the corporator, provided further that the expression related party shall not include financial entity. So here they are clearly saying that the concept of related party, related entities, those concepts will not be applicable to financial entity because they are separately regulated by RBI. So that's why to them these regulations will not be applicable. Explanation 2. For the purpose of this section, financial entity mean, already we have discussed, financial entity means, okay, so following entities which meet certain criteria and conditions as the central government may prescribe. So financial entities include scheduled bank, any entity regulated by foreign central bank. Here we are having RBI. In the same manner in other country, okay, any central bank or securities market regulator or other financial sector regulator of a jurisdiction outside India. So if any person is regulated, maybe by SEBI or maybe Securities Exchange Commission or foreign central bank, like that, okay, so any regulatory authority, then in such cases such entity is considered to be financial entity. So any investment vehicle registered foreign institutional investor, registered as foreign portfolio investor or a foreign venture capital investor where the terms shall have the meaning assigned to them in regulation 2 of FEMA. Okay, so if any investment vehicle registered foreign institution, because for them separate rules and regulations are applicable, okay, to them these regulations will not be applicable. Okay, and asset reconstruction company under the SARFAESI Act or alternative investment fund registered under the SEBI, okay, such categories of persons as may be notified by the central government, they are considered to be, they are not considered to be related parties. Okay, so till here we have discussed the definition. Okay, so we have discussed the section 29A in detail where the persons who are not eligible to be resolution applicant. Till now, in the next lesson we are going to discuss in detail about section 29A.
Let us recap what we have discussed today. So in today's lesson, we have discussed the concept of person ineligible to act as a resolution applicant. So who are ineligible to act as a resolution applicant, we have discussed. Then we have discussed the provision of section 29A in detail. Then who is considered to be connected person. Then we have discussed about who is financial entity. So in today's lesson, we have discussed person who is ineligible to act as a resolution applicant, half of the part. Remaining half we are going to discuss in the next session. Thank you.